Hi, everyone. Harry here to talk about the cutting edge case that the Supreme Court has accepted for review for next term. It is United States versus Skirmetti, and it involves the rights, or in this case, the absence of rights for minors in Tennessee to have any sort of treatment for gender dysphoria, to become a trans individual. Tennessee has passed a statute saying, one, you can't have any treatment, medical treatment, to live as a purported identity inconsistent with the minor's sex. Even that's a pretty loaded term, right? It's purported identity, as if it's not somehow a real impression. But then it goes on to say, or to treat purported discomfort or distress from a discordance between the minor's sex and asserted identity from gender dysphoria. So if you read that fully, it sounds like you can't get psychiatric care, no treatment. So quite harsh and broad. All right. So this comes to the Supreme Court from a decision, a very long, comprehensive decision by a very respected judge, Judge Sutton, who goes through all kinds of different challenges to the statute on the basis of different constitutional provisions. The Supreme Court, however, has limited its review to equal protection. And Sutton's equal protection analysis, well, it focuses on supposed discrimination on the basis of sex. I'll get to that in a moment. First, he does away with on the basis of age. Adults can get such treatment, but not children. But that's, nothing really unusual in for certain medical treatment. And then gender dysphoria itself, but he analyzes that as just a condition that if you're not comparing, just a condition that the state can, in normal kinds of determinations, single out certain kinds of maladies and pathologies from others. But then the big question is this discrimination on the basis of sex? And hovering in the background here is the decision a few years ago written by Justice Gorsuch, finding that sex discrimination within the meaning of Title VII, a statute that governs employment, includes discrimination on the basis of sexual orientation. So that's a task that Sutton just determines that the statute is okay. And this, the argument for equal protection violation on the basis of sex is what he sets his sights on, having the most sort of comprehensive treatment. And that's because Bostock is out there. So what he basically says, first, his own analysis is it's not on the basis of sex. Girls with gender dysphoria, boys with gender dysphoria are treated the same way. So, now you might, but girls with gender dysphoria and girls without may not be, but that's the previous kind of distinction having to do with particular medical conditions, and a state, that is generally not constitutionally required to give every possible entry in the DSM-5 or whatever equal treatment. So it's sex. And that's his basic argument. It's not discrimination on the basis of sex because boys and girls are treated the same. He then goes to the Bostock case and needs to distinguish it. He knows this case could well go to the Supreme Court, as indeed it now has, and what's going to happen with Bostock. So after going through all the different challenges, there's a whole section. Bostock doesn't compel a different conclusion. And first and foremost, and this will be the focus in the Supreme Court, and I think the betting odds would be the Supreme Court affirms and that it upholds Tennessee statute and distinguishes Bostock on this basis. Bostock is Title VII, a statute, and this challenge is that the Constitution precludes it, and there's all kinds of reasons, sort of basic canons of the court that say you can't just equate sex discrimination as forbidden by a statute with the constitutional principle, among other things. He says, Sutton, look, if this were right and it just that you could import the result from Title VII, then you would also have to import, for constitutional reasons, all the defenses that Title VII includes: bona fide, employment, classification, and the like. And that's just, couldn't be the case. Title VII builds its particular whole structure and scaffolding of prevention of discrimination on the basis of sex in its statutory setting. So they're going to say, and it'll be really interesting where the court is and where Gorsuch is, but they're going to say, in addition to the main point that this, according to Sutton, isn't sex discrimination because boys and girls treated the same. You might think, boys and girls are treated the same, but we just found in Bostock that sexual orientation has to be incorporated as a matter of discrimination. So it's the analog there would be that gender dysphoric and non-gender dysphoric minors aren't treated the same, as indeed they aren't. But that he, Sutton said, just puts on the sort of list of, you don't have to equally treat all kinds of, every kind of problem or disease or syndrome. If a state chose not to give its resources to the treatment of a particular psychological issue or whatever, that's usually subject to what they call rational basis review. Basically, they can do it. So that's where we are, and the court takes the case, and it's going to have obviously huge implications. First and foremost for transgender minors, but it's going to more generally, the big action's going to be in focusing on sex discrimination and whether the Bostock case, which was, Gorsuch took a straight, as he saw it, textualist approach. Sexual orientation is part of sex. And you could say that the same reasoning should apply to in the constitutional area. And there's been, one of the reasons they probably took the case is there's been a series of cases below that, in the lower courts applying Gorsuch's reasoning in equal protection for discrimination against transgender people. So that's going to be the next sort of closely watched discrimination case in the Supreme Court. And the question will be whether the Constitution will give the same kind of protection to trans minors or even trans people. It'll have broader implications for sure, as it does to discrimination against men qua men, women qua women, the equal protection on the basis of sex. I think most people would predict that the court will draw the line, affirm Sutton, and come up with some way of distinguishing Bostock. But it'll be pretty interesting given how sort of textualist and definitive the Gorsuch opinion in Bostock was. How do they kind of get out of that particular textualist analysis? Because text is the same word, sex discrimination, basically. Okay, so that's something to start watching closely, even as we await with bated breath the final decisions of this term, that we look ahead to some of the big ones that they'll be deciding next term after the summer when they return, first Monday in October, and the court's work goes on. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.